mean, it was a tough case.
Right now.
I thought if anybody could have.
All right, can everybody hear me?
I think it might walk. She might walk anyway.
I think if you got that statement in.
Yes, and we can see you too, Judge.
Okay, great. Good afternoon, everybody. My name is Judge Kathleen McHugh. I will be the judge presiding over magistrates here this afternoon. I have reviewed the probable cause affidavits for each of your cases. I'm going to make a probable cause determination, and then if I find probable cause, I will set a bond amount. First case I have is Simona Bailey.
Yeah, you got to pass this thing down.
Not the main jail.
Questions first?
Your Honor.
Broward?
Yeah.
Simona Bailey, North Broward?
She's on her way right now. Sarge is bringing her.
Okay.
She's on her way.
What's the ETA?
A minute. 1 minute.
You have Michael Sheehan in Maine. He
All
might be
right,
there.
let's do Michael Sheehan, Maine Jail.
Page 9, Dale.
Come on. He's present, Judge.
Okay, good afternoon, Mr. Sheehan. You're here for two matters. The first one is causing bodily harm for disability. And the second is a capias on a misdemeanor ordinance violation. I'm appointing court-appointed counsel for you on that case.
That's Drew.
And does the defendant have any prior criminal history as to the aggravated battery charge?
Mr. Sheehan's third arrest in about a month.
No.
He was
You
arrested
signed- he
May
needs that.
6th for possession of heroin,
He's got Drew
cocaine,
on
and
there.
DWS. He posted bond charges have still not yet been filed. Then he was arrested again in May, and charges have been filed for burglary of a structure resisting without violence. He is currently out on those charges. Your Honor, it's up to the court whether you choose to do so sua sponte or not, but the state would recommend that his bond be revoked, and that he has now violated his release conditions on 2 cases with an allegation of violence.
What are the two charges again that he's out on bond for?
The drug charges, and I'm not recommending that his bond be revoked because it's been more than 30 days. The state hasn't filed charges.
Okay.
But there is burglary of a structure and resisting without violence, and those have been filed.
Okay. All right. All right, I do find probable cause to detain you as to the aggravated battery causing bodily harm. And I am going to revoke your bond on the burglary structure. And what was the other charge?
Resisting without violence.
Resisting without violence.
And that's
Okay.
under case number 6142 CF10A.
All right, bond will be revoked. I need an order to that effect.
I'll prepare an order for you.
Okay, and then as to the aggravated battery charge, what bond is the state recommending?
Your Honor, based on the level of violence alleged in this case, the injuries suffered by the alleged victim losing a tooth, Your Honor, I'd be asking for a $10,000 bond, no victim contact.
Mr. Miller, anything you'd like to add?
Judge, there's not a whole lot to add. He does have a job. He's been living here for a couple of months. He does have family here in South Florida, and he's going to have to self-bond. $10,000 is a tantamount to no bond, but I understand that he doesn't, that you revoked bond in the other case as well.
Okay, I'm going to set bond in the amount of $10,000. He's not to have any direct or indirect contact with the listed victim in the case. If he's in the possession of any firearms or ammunition when he's released, those are to be surrendered to his local police department.
Your Honor, I have Miss Bailey at North Broward.
15-6142.
All right, Simona Bailey. You're here this afternoon for a municipal ordinance violation. If you find probable cause to detain you, your bond has been set in the amount of $100, and I have appointed counsel to represent you.
Would the court be interested
Judge,
to resolve it?
regarding Mr. Sheehan,
I'm not ready to go back to Mr. Sheehan yet. I'm still on Mr.
Sorry.
Bailey. Yes, does the state have a recommendation to actually...
Well, it's a city.
Is there a city prosecutor present?
No. I can contact them and see if they're coming. They generally know to come in the afternoon, but
Right. At this point, I'm not inclined to resolve it until I know
I
what the
understand.
recommendation is from the city.
I understand. You also reset Jacob Mathis from this morning? Yeah, main jail?
Who are we looking for?
Jacob Mathis.
Mathis?
Page 12 from the morning? Reset?
I don't see him there.
Maybe not.
All right, what else you got, Mr. Adrian?
That's it, Your Honor. Thank you.
Okay, thank
I'll
you.
contact the city.
All right, next
Judge,
case.
did you appoint Mr. Atria on Mr. Sheehan's case?
Yes, I did.
Thank you.
All right. Next case I have is Dwayne Walker.
He's president of the Maine Decline PD. Here you go.
Okay, good afternoon, Mr. Walker. You're here
I do have the case number.
in regards to your arrest on a touch or strike battery, domestic violence. I do find probable cause to detain you. Does the defendant have any prior criminal history?
One moment. Chief, did you have anything, or did you run and check on him?
Were you arrested by yourself? Do you work?
Reckless driving and resisting?
Do you work? What's your take on that?
All right, I do find probable cause to detain
How
you.
much do you take on, sir?
You set bond in the amount of $2,000. You're not to have any direct or indirect contact with the listed victim in this case until further order of the court. If you're in their possession of any firearms or ammunition, they need to be surrendered to your local police department.
They were being reported and they got you at 200.
Okay.
Michael Calloway.
Okay.
How much is the bond?
2,000.
Michael Calloway.
Leave now?
There.
Just go down the middle out the door. Judge, I don't know where he is.
Bond out.
Callaway, guys? Anybody?
All right. Counsel, do you have a case you call?
Yes, Your Honor, if you would. Ms. Hogan from the statewide prosecutor's office and I have Calvin M. Bynum, B-Y-N-U-M,
Good morning, Your Honor. Julie Hogan on behalf of the Office of Statewide Prosecution.
and Dave Bogenschutz on behalf of Calvin Bynum.
Judge, there is a bond order that was signed by Judge Scheer, and actually the case is currently in front of Judge Scheer. She's been hearing the bond hearings with regard to the co-defendants in this matter, and I would ask that this case be reset over to her courtroom.
No opposition, Judge.
Okay. All right, I'm just looking for the paperwork in regards to this.
Find him.
My credit card promise to transport put everything together.
It's fine. Sit right there.
This is over declining the services of the public defender. Could you sign there, please?
All right, good afternoon, Mr. Bynum.
Good afternoon.
Thank you.
Here this afternoon for your first appearance in regards to 4 matters. Racketeering violation, count 2 is a racketeering violation, count 3 is a manslaughter charge, count 4 is also a manslaughter charge. Bond on each of those 4 counts has been set already in the amount of $150,000 for each count. I don't have any factual information in regards to any of these charges. I understand that the judge that's going to be presiding over your case wants this to be transferred to her for any future hearings in regards to the setting of bond in this case. Is that correct, counsel, for the state?
Your Honor, on count 1 of the special bond conditions, it does indicate that the bail may be modified by the trial judge to whom the case is assigned, or the chief judge. Since Judge Scheer actually signed the warrants, and she is in the process of hearing the bond hearings for the other co-defendants, I would request that it be sent over to Judge Scheer so that there's a consistency in her thought process on the bonds.
And Judge, on behalf of Mr. Bynum, this is Dave Bogenschutz. In case Mr. Bynum can't see me right now, I agree with that. We're trying to work something out with the statewide prosecutor if we can at this point, so we would ask that that be done.
All right, well, at this point, sir, the bond totals on all 4 of these counts is in the amount of $600,000. Can we set the court date in front of Judge Scheer now, or are you going to go call?
So I think we'll probably have to do that, and I'll set it down, file a motion, so.
Okay. All right, sir. You're going to be going in front of Judge Scheer for further hearing in regards to these matters.
And I will
Okay,
be up to
thank you.
see, Mr. Bynum, I'll be up to see you sometime in the next probably 24 hours to discuss this with you.
Okay, thank you.
All right,
Thank
thank
you,
you.
Judge.
Thank you, Your Honor.
Nice to see you, Judge.
Good to see you as well. Next case I have is Johnny Love. Is he in the main jail, Johnny Love?
You gotta put your mic on, Dale. No.
All right, this is Mr. Love.
Okay, Mr. Love.
Mr. Calloway, who you called earlier, is at Paul Run.
All right, Mr. Love, you're here in regards to an aggravated battery. You knew or should
Yes.
have known the victim was pregnant. And a second count of a probation violation or community control violation, which is being held for bond. Does the defendant have any prior criminal history?
I'm just checking to see if there's anything in addition to what he's on probation.
Judge, although it says that the cop makes a statement that he was aware, it seems like a conclusory statement. Didn't see anywhere in the probable cause affidavit, I may be incorrect, but where he admitted knowing that she was 2 months pregnant.
Okay.
In addition, Your Honor, he's got federal priors. 2005, possession of a firearm by convicted felon. Could you answer that for me, please? Could you answer that for me, please? And 2002, smuggling contraband into jail at a Dade. 2002, possession of marijuana at a Dade. Smuggling contraband into jail, 2001 in Dade. Uttering 01 and grand theft. Possession of cocaine, 98 out of Dade. Sale delivery of marijuana, 95 out of Dade. Strong arm robbery, 94 out of Dade. End of record, Your Honor.
All right, I do find probable cause to detain you. I'm going to set bond on this. Does the state have a recommendation for bond?
Your Honor, I would just be asking for a $6,500 bond, no victim contact.
Okay. Mr. Miller, anything you want to add?
Judge, again, it's just window dressing. He's not going anywhere.
All right.
He's
All right, I'm going to set bond in the amount of $5,000. He's not to have any direct or indirect contact with the listed victim until further order of the court, and if he's released, he needs to surrender any firearms or ammunition to his local police department.
Thank you, Judge. All right, good luck.
Go.
Marlene, come on.
Next case I have is Jennifer Rivera.
She bonded, Judge.
Bonded? Okay. Sentinel.
She is present at the main.
All right. Good afternoon, ma'am. You're here in regards to burglary, unoccupied structure, unarmed, second count of criminal mischief. Not being held in criminal mischief charge. Does the defendant have any prior criminal history?
One moment.
Judge, we need a photo order for Miss Villa Sentinel.
Granted.
Thank you.
I don't have anything, Your Honor.
Doesn't appear she has any prior criminal history. Is pretrial?
Judge,
Yes.
before we go too much farther down this road, I've just reviewed the probable cause affidavit, and it seems a bit conclusory. It doesn't have any factual information to explain how it arrived, how the arresting officer arrived at the conclusion that this woman broke into this house. No fingerprints, nobody saw her, nobody recovered property from her. It's just conclusory that she did it, and it doesn't say how they know that she did it. So I'd argue that there's no probable cause based on the four corners of this affidavit. If there's other information that I don't know about, that would be different, but this is not probable cause as far as I can tell.
Yeah, Your Honor, that's fine. I'd ask for 24 hours. However, though, I would ask that the court, that a bond not be set until we come back.
Tell you what, I am going to find, she doesn't have any priors, correct?
Not that I see. Just prior arrest, but they were all dropped.
All right. I'm going to set bond on this matter in the amount of $500.
Mr. Keel.
500?
500, yes.
Thank you, Judge. Okay.
Sydney Cottage.
President Domain.
Good afternoon.
Good afternoon.
Two cases on two separate misdemeanor charges. Bond on each of those charges has been set in the amount of $250 on the first, habeas, $500 on the second. Your court dates for those two charges are June 16th and June 10th at 9 a.m.
Michael Williams, Michael. Say again, Your Honor.
June 10th and June 16th at 9 a.m. for each of those misdemeanor cases. You have two court dates coming up.
Okay, I told you that. Okay.
Michael Williams.
Off you go. President Domain.
Okay. And his father, is it your father? Would you like to be heard?
Ask the court to release it to me.
All right, Mr. Williams, you're here for DUI, alcohol or drugs, first offense. I do find probable cause to detain you, and your bond has been set in the amount of $500. Does the defendant have any priors?
Do you have an attorney?
No, Judge.
He has no priors. And he's how old?
26.
26.
Sign right there. Invoke your Fifth Amendment.
All right, his father's present in court. He's got no prior criminal history. I'm going to
Will you
ROR him to your
identify
custody.
yourself?
Thank you, Judge. You go down the middle, out the door, and they'll release you sometime in the next 8 hours. Get out.
Make sure he doesn't miss any future court dates.
Yo.
All right.
And hey, it's up to you to stay on top of the case.
Lagerberg.
Online, on the phone, and if you have anything in court, to appear. If you don't, they'll invoke the bond and rearrest you. Good luck. He bonded, Judge.
Okay, great. Jorge Garcia.
Paul Ryan,
Paul
Your Honor,
Ryan?
he's in court.
Jorge Garcia.
Paul Ryan, but he's in court.
Joe Williams? Joe?
You wanna?
Yes, Your Honor.
Tomorrow morning?
That's fine.
All right, reset that till tomorrow morning.
Date of birth. This is not gonna get date of birth.
Joe Lorenzo Williams.
President Domain? Kenneth?
All right, good
Your Honor, I
afternoon.
got Mr. Calloway, Paul Ryan.
Okay, all right, I'll go back to him right after I finish.
I'm gonna finish you guys before she gets it.
Okay, Mr. Williams, you're here for violation of community control on a felony and a grand theft. Violation of the community control, you're being held no bond. I do find probable cause as to the grand theft, and your bond has been set in the amount of $1,000.
Thank you, Judge. Okay. We'll see
All
the
right,
judge
back to,
on Wednesday.
Mr. Calloway, that was Paul Ryan, you said?
Yes, Your
Yes,
Honor.
Judge.
All right, Mr. Calloway, you're here for a capias on a grand theft in the 3rd degree. Bond has been set in the amount of $1,000. Your court date is June 10th at 8:30. Kenneth Roach.
Yes, ma'am. President Domain?
All right, good afternoon, sir. You're here for a violation of probation on a felony charge. You're being held no bond. Your next court date is June
Newman?
16th at 8:30 a.m.
Thank you, Judge. Right down the middle, out the door, Mr. Newman.
Good afternoon, sir.
Andre
Ma'am.
Newman.
Good afternoon, ma'am.
Decline
Good afternoon,
PD,
sir.
Judge.
You're here on a violation of probation on a felony charge. You're being held no bond. Next court date is June 10th at 8:45.
That's Wednesday.
Okay, thank you, Your Honor.
All right, good
Good
luck
luck.
to you.
You're $1,000 and you afford your bond. I don't have anything else.
Lyndall Smith.
I don't believe.
Yes, ma'am.
Any cases.
All right, Mr. Smith.
Yes, ma'am.
You're here for resisting an officer without violence, 2 counts. Count 3 is a corruption by threat, and count 4 is a probation violation, for which you're being held no bond. Does the defendant have any prior criminal history?
Your Honor, I can check. I can't tell you based on and what I have learned. On count 4, he is a registered sexual offender. So, and he's being held no bond on that.
All right.
Were you injured when you were
Judge,
arrested?
I'd like to be heard.
There are additional priors.
Okay. All right, Mr. Miller, do you want to add anything?
Yes, on as to count 3, Judge. Count 2 and 3. I think count 2 is redundant. Resisting, he ran, he didn't answer names according to the answer questions
He's not
according
being
to the
held
PC.
on the resisting charges.
On count 3, Judge, the statement, "I wish I knew where your family lived," cannot in any way be interpreted as a threat. It's not a future threat. It's not a threat of future harm. There's no quid pro quo. Either you do this or I'll do that. There is absolutely no crime here, Judge. Count 3 is no probable cause. I would ask the court to find no PC. And in light of that, I would ask the court to give him a bond in count 4.
Well, first off,
That's a probation violation.
and Your Honor, I think
And,
there is.
All right. What are his priors?
I will. All right. His priors are
Bunch of cars.
2004
He's
legal
Paul
and
Rowan.
serious molestation.
It's over.
Yeah.
Got priors out of Ohio,
The judge.
soliciting.
Okay, dokie.
One moment, Your Honor. It's just not easy to read this. I see previous arrests in Ohio, but I can't really tell what is and or what he was or wasn't convicted of. Your Honor, I would agree. Count 3. There's no PC for count 3. However, I do think there is PC for counts 1 and 2.
He's not being held on count 1 and 2.
No, but the 1 and 2 form the basis for the violation of probation.
Okay.
Because I would agree if there was no PC for anything,
Right.
then
You agree there's no PC for corruption by threat?
no, I would agree that I think it could be interpreted as a threat, but it takes more than a mere threat to satisfy corruption by threat.
Okay. All right.
You ready?
I'm going to ROR you on the corruption by threat charge, but you're still being held no bond on the violation of probation. Your court date is June 15th at 8:30.
Okay, thank you, Judge. That's Monday.
Willie Lee.
Willie Keel. Willie Keel. Decline PD. Willie. Willie Keel. Willie, come on.
All right. Good afternoon, Mr. Keel. You're here for
Goldstein, you're next.
count 1 is a false ID given to Leo. Count 2 is possession of heroin. Count 3 is drug paraphernalia possession. Count 4 is possession of cannabis, and count 5 is a violation of probation on a felony for which you're being held no bond. I do find probable cause as to the possession of heroin, and your bond is set in that matter in the amount of $1,000. Your next court date
Thank you.
will be June 16th at 8:30.
Thank you, Judge.
Thank you.
Okay, off you go. I'm down now.
Real Napoleon.
He bonded, Judge.
Austin Goldstein.
Main jail, Judge.
All right. Good afternoon, sir. You're here on 2 matters of possession of a controlled substance without a prescription. Bond has been set in that matter in the amount of $1,000. I do find probable cause. And the second is an intimidation, writing or sending threats to kill or injure. Does the defendant have any prior criminal history?
2008 burglary of a dwelling and theft. 2008 burglary of a conveyance. Patrice, did you have anything other than that? Okay, that's all.
All right, I do find probable cause to detain him. Anything you want to add, Mr. Miller?
Judge, I would argue that there's no probable cause because it doesn't say how they came to the conclusion that this man is Dee's errand.
Your Honor, based on the reports, they relied upon his admission.
All right, I do find probable cause. Because of the threats to kill, I'm going to set bond in the amount of $3,000. Level 2, GPS, pre-trial.
Thank you, Judge.
All right.
Your
So
Honor,
$4,000
did-
pre-trial
Also,
relief
sir,
level
no
2.
contact with the listed
4,000?
victim, direct or indirect.
So what does that
Possession
mean,
of any
pre-trial
firearms or
relief level
ammunition, you need to be surrendered to your
I'll
local
explain
police
it.
department.
and
What
Your
do you
Honor,
want to say, Mr. Miller?
yes, if you could just, if there could also,
Okay.
could also, could you have, well, I want to make sure he's listening.
Where's Mr. Goldstein? Okay, what did you want to add, Mr. Linder?
If you could just also include that he's not to return to the location Cheers Bar
Can't
and
go back to
restaurant.
Cheers Bar. Where is Cheers Bar? Boston?
It's in Boston, Your Honor.
I think it's in, I think, I want to say, I'm not sure if it's Fort Lauderdale or Oakland Park. I mean,
All right, next case, Anthony Silva.
Anthony Silva? Is that who you call, Judge?
Yes, Anthony Silva.
President, the main judge, I think he's going to be hiring private counsel.
Okay, good afternoon, Mr. Silva. We're here in regards to a robbery with no firearm, battery causing bodily harm, and 2 probation violations or 3 control violations for which you're being held no bond. I do find probable cause as to the battery charge, which you're being held on that $1,000 bond has already been set. Doesn't have any priors.
Your Honor, in addition to the 2 cases he's on probation for in 3 and 4, DUI 04, possession of cocaine 89, DUI 91, DUI 88. I don't see anything else out of Broward, Your Honor.
All right, I'm going to set bond in the amount of $3,000 on count 1. The next court date, sir, is June 10th at 9 a.m.
Thank you, Judge.
Thank you, Your Honor.
Your Honor, I'd ask for no victim contact.
Also, no contact with the
No
listed
contact.
victim.
Good luck.
Sir, no
Means you
contact
can't-
with the listed victim. Mr. Miller, tell him there's no contact, direct or indirect, with the listed victim.
Right, can't call her, can't write, text, email, no.
Okay,
Okay, good luck. Okay, I've got 2 second looks here, Judge.
All right?
The first one is Thomas Wyckoff. I've already advised him that the charges have been filed. How you doing here?
Good afternoon.
He's here on a 30-day motion, Judge.
All right, has the state filed?
Well, yeah, I don't know if
They
the
have.
public defender's conceding. I think Mr. Miller already checked out as he saw that it has been filed.
Okay, the case has been filed. Mr. Linder has told me in court that the case has been filed. Does the public defender have the same information?
Yes, Your Honor. I reviewed it and it says everything appears to be in order.
Okay. All right. And what else do you have for a second look?
Okay, you're on your way. I have
Wyckoff.
Timothy Couture, Judge. It's a misdemeanor second look. He's been in custody since June 3rd on a trespass. He
What's
is
his
anxious
name?
to resolve.
What's his name?
Timothy Couture.
Okay. He's been in
And
how
he
long
would
on a
like-
trespass? 60
Since
days?
June 3rd.
6 days.
Just checking to see what's going on in this case. Thomas Wyckoff is the last
Yeah,
case.
he just went out.
Yes.
State have an offer for him to resolve it.
Your Honor, I'm just pulling the PC. I just want to make sure that this, whether this was a private citizen's home or anything like that.
I don't know what his bond was for the R1.
Yeah, we've had that in a minute.
It was $100.
It was
Judge.
250,000, but you don't have to really get into that
Okay,
because it just
all right.
strictly did we file charges.
Okay, gotcha.
Okay, and on his, Mr. Couture's case. Yeah, Your Honor, the reason, and I really can't make an offer, I remember this case now. The reason it wasn't, I believe Judge Lee or gave an offer last week is because this involves somebody's home.
Okay. What was
And
Judge Lee's offer last? The
I
reason
don't know.
why he did not?
I did not, and it was either Judge Lee or Judge Dishwitz, but they
Okay.
did not make an offer because it involves a private individual and not a store or a gas station or something like that.
Okay. And can you tell me if he has priors, though?
Yes, Your Honor, I can. Yes. strictly prior state charges out of Broward. He has, I think this played a part in too. Last year, violation of a domestic violence injunction. Last year, violation of a domestic violence injunction, possession of marijuana. 2013 theft. 2013 felony petty theft. 2013 theft. 07 disorderly intoxication. 09 theft. 99 burglary of a dwelling with a VOP, 6-year state prison. 99 burg dwelling and grand theft with a VOP, 6-year state prison.
No, I'd say transfer this to a regular division when and if it gets
Thanks,
filed.
Judge.
I'm not gonna resolve it. All right,
Thanks,
anything
Judge.
else?
I can't get RO.
We are clear at the main.
All right,
Get
great.
RO because I'm in. and I
I
can't-
have,
Judge,
I still have,
You just gotta go through
I
the-
still
You're gonna
have
have to have
DeVille
for
on
debate.
Broward.
Yeah,
And Paul Ryan has Lorraine.
Where we going, Paul Ryan?
yeah, they're all competing.
Paul Ryan
for
has
your
Lorraine.
All right, Paul Ryan.
Oh, Lorraine Francisco. Your Honor, if I could just have one moment, I'll print out.
Is this a 30-day rule violation?
It is, sure.
Okay. What's this defendant's name?
Lorraine Francisco.
All right.
I'm just printing out a copy of the page from the from Odyssey.
All right, so it has been filed?
Yes.
All right. What's the charge?
Aggravated assault and battery. It's a felony.
Okay. All right, the state attorney's office has filed charges. It's an aggravated assault, and what was the second count, Mr. Linder?
Battery. I'm not
And battery.
Sure if this file was charged. I know it was some information was filed.
Okay. Public Defender's Office concur. Okay. The motion for ROR based upon a 30-day rule violation is denied.
Okay, excuse me, ma'am, can I say something?
You can, but what you say is being recorded.
That's okay, ma'am. I actually went to court last Monday, and my judge ordered me for pretrial release on a GPS monitor. I've been waiting since last Monday for my ankle monitor. My mother called my pretrial release officer, and they said that the first address was denied. So I went ahead and gave them another address, and that one was approved with another family member, and I'm still waiting for a judge's approval for that second address.
All right.
I don't know how long that's gonna take for the pretrial, or
What's the name of your judge?
Judge Cohen.
Judge
Jeffrey
Cohen.
Cohen? Okay. All right. Well, you have the Public Defender's Office representing you. If there's an issue getting you released on pretrial, have them set up a hearing in front of Judge Cohen.
Okay, thank
What else do we
you.
have?
You just
Your Honor?
either Conti or North Broward.
All right, let's go to North Broward.
I got
Broward.
Kelly DeVille from this morning. You wanted her brought back?
Right, Kelly DeVille.
Come on. And on yes.
All right, good afternoon, Ms. DeVille. You're here
Good afternoon.
on a capias on a misdemeanor loitering, soliciting an act of prostitution, on a misdemeanor ordinance violation. Bond has been set in the amount of $100.
Judge, would the court appoint counsel, or?
Which city is this?
What's the case number, Judge?
This is case number 151712, MO 40A,
This is a Hollywood case.
Hollywood. All right.
Mr. Shade, yeah, Mr. Shade is
I'll
a
put
Hollywood
counsel
attorney.
form to appoint him.
Steve Shade.
All right, your bond is set in the amount of $100, and I have appointed counsel to represent you.
All right, Your Honor, Conti.
All right, Conti, who do we have here?
This Jared Wetzel.
All
This
right.
is also a 30-day motion. I'm just printing out the page to show
All right.
counsel. It has been filed. Just reading off the information.
Hasn't been filed.
Has been filed.
And we filed from aggravated battery to felony battery prior conviction. Who's this on? Weitzel. Jared Weitzel.
Okay, all right, sir, the state has filed charges. We're just giving that information to the public defender to see if they agree. All right.
Is the bond adjusted if they downfiled it?
No, I mean, these are given specifically to these types of cases. At this point, Your Honor, I mean, he can certainly file for a motion to modify bond in front of Judge Rothschild.
Okay.
But
All right. Motion to release from
Your
custody
Honor?
based upon a 30-day rule violation is denied. The state has filed charges in a timely manner.
Your Honor, can I
Yes,
say
sir.
something, please?
Yes, sir.
I was sober for 3.5 years until 2.5 months ago when me and my fiance relapsed, and this battery is with her.
Don't talk about the facts of the case. If you do, everything is
I'm
being
not going to
recorded.
talk about the facts.
You're starting to go
I'm
into the facts, sir. I'm just.
Okay. All I'm saying is I relapsed after 3 years sober, and I have a program, 12-step fellowship, that is willing to take me if I could be released. I have a job waiting. I manage a phone sales office, and I've been out of work now 35 days, sitting in jail, waiting to go home.
All right. Well, bond is set now, and how much? What's the amount?
I'll tell you right now, Your Honor.
I mean, is there any way you could release me to 12-step fellowship on a monitor or something, ma'am?
Total bonds, $11,000. There was also possession of cocaine, and he had a capias on the DWLS, and he has multiple priors.
All right, sir. You have multiple prior criminal history. You have a total bond amount of $11,000. So I'm not gonna entertain any request to reduce your bond at this time. You can go in front of the judge assigned to your case and request a bond reduction. All right. Do we have anything else?
We got a few more, Judge.
All right.
Let me go behind you.
Is that a Conti?
Yeah.
Okay.
Conti has 5 guys.
All right.
This is Will Lewis.
Will
Okay.
Lewis.
This is
30-day
also
rule violation?
Yes,
All right.
Your Honor. I'm just printing out the page on this.
Drew, I just appointed another on Mr. Shakes. Kelly, what is that? Kelly last name or first name?
I'm sorry. I think so, but let me.
Yeah.
They also.
I
I'll
found
tell you
another
something
one.
else in a second.
MO 40, please.
Your Honor, I'm printing out a copy of from the clerk's register for counsel. But if you want, you can inform Mr. Lewis. We filed burglary of a conveyance of battery as charged, and it looks like added account of attempted carjacking.
Okay, sir, the state attorney's office has filed charges against you. Your motion to release from custody based upon a 30-day rule violation is denied. They filed burglary of a conveyance and carjacking, you said?
Attempted carjacking, Your Honor.
And attempted carjacking. Can they hear you when you talk, Mr. Linder?
They can. I just think it's more official coming from.
All right.
It is a bit.
Yes, ma'am.
It's
They can hear you.
redundant.
I know, but I feel like they can't hear you because you don't have a microphone right here, do you? Oh, there you do. Okay.
It's hidden, but.
It's hidden. Okay. All right. Which
Sometimes I
case
wish
is
I
this?
did have one.
This is James Barber.
All right, James Barber.
Okay, this is another 30-day, and we have filed, Your Honor. I'm printing that out.
Okay. All right, Mr. Barber, unfortunately for you, the state has filed charges against you.
And
if I may too, I got 3 witnesses that say I didn't do any of this. If my public defender can talk to the prosecution, they'll see it. All they have to do is make the phone call and get the phone records.
charges that were filed were armed burglary of a dwelling, dealing in stolen property, possession of a firearm by a convicted felon, and 2 counts of grand theft firearm.
Did you hear that, sir?
2 counts of grand.
Yes.
Okay. All right.
Yes,
Your
sorry.
release from custody based upon 30-day rule violation is denied.
All right, Michael Kelly.
This is a second look, Judge. It's a theft case.
In custody 6 days.
Just looking up some of the info. Okay.
Yeah, they're liars. That's state lies all the time. Yeah, me too. I can't get back there and call my lawyer. Mine either. I check it every day. downgraded my charge.
Just trying to see when he was arrested.
I gotta look that up. It ain't what it was, aggravated battery.
Okay. Your Honor, the state's offer at this time would be an adjudication time served, just so the court has a factual basis. He was seen entering Rack Room Shoes in Pompano Beach. He took a new pair of shoes valued at $59.99. He tried them on. He exited the store still wearing those shoes, leaving his old shoes behind. He was stopped outside still wearing the merchandise taken from the store, and the incident was captured on video surveillance. His criminal history, as far as Broward, I can tell you, resisting without violence, 03, battery, 02, possession of cocaine, 87.
This is Mr. Kelly, right? That's his name?
Yes.
Or Mr. Kelly, the state's offer is an adjudication, 6 days in the Broward County Jail, credit for 6 days served. Do you want to resolve your case today?
Yes.
Judge, may I just advise him that from what I understand, this is your first theft conviction. If you are charged with an additional 2 thefts, or if you're convicted of another theft, and the state can charge you with the 3rd theft as a felony.
Do you understand that, sir?
Yes, Your Honor.
And you still want to plead guilty, right? Or no contest?
No contest.
All right, you want to raise your right hand? Swear firm, tell the truth, the whole truth, nothing but the truth.
I do.
All right. Did you say yes?
Yes.
Okay, place your
Yes.
hand down. Please state your name for the record.
Michael Kelly.
All right, sir. Do you want to plead guilt? Do you want to plead no contest to this charge?
Yes.
All right. You understand you give up the right to a trial by jury.
Yes, I do.
You give up the right to confront and cross-examine witnesses.
Yes.
You give up the right to have the state prove these charges against you beyond and to the exclusion of every reasonable doubt.
Yes.
And you give up the right to an appeal. If a jury would have returned a guilty verdict, you could appeal that judgment and sentence to a higher court. You want to waive all those rights?
No.
You don't want to waive those rights?
No, Your Honor.
Why not? You just said you wanted to resolve this.
Oh, yes, I want to resolve it, yes.
All right, okay. All right, I'm going to adjudicate you guilty, sentence you to time served and court costs. Best of luck to you, sir.
All right, thank you.
I think that's it.
No, I got one more, ma'am.
All right, great.
It's a possession cocaine.
30 days.
Oh, yeah, you're right. Yeah, who's this one? This is Maurice McCormick. Yes, Your Honor. We have not yet filed an information on this case. Mr. McCormick is entitled to release.
Released?
Yes, Your Honor.
What's the charge?
Possession of cocaine.
All right, you want some good news, sir?
Yes, sir. Yes, ma'am.
All right. I don't know why everybody calls me sir.
I'm sorry, Judge.
Maybe it's
I
my
didn't mean
tone of
that.
voice.
I don't
No, it's not your turn. It's not your turn of voice, Judge.
All right, well, today's your lucky day because the state has not filed charges against you, and it's
That was deleted off the docket.
they've not established good cause to hold you any longer, so I'm going to release you on your own recognizance.
Okay, Judge.
All right, that doesn't mean the case is over. It just means that they can't hold you in jail any longer. So if the state does make a filing decision sometime in the future, you're going to need to come to court. So
Okay.
make sure that you are apprised of when your future court date is if the state does make a filing decision.
Yes, ma'am.
Okay, best of luck to you, sir.
Judge.
God bless you too.
All right, good luck to you.
Judge, there's a case that was deleted from the docket. She's been on the second look docket twice. Carolyn Marceau.
Okay.
Will the court reset that matter for tomorrow? It's a
You know why
misdemeanor.
she was deleted?
I don't know.
Carolyn Morceau.
She was up
in
on
custody?
Friday, and then they said it was a medical reset, so we reset it for today.
All right.
And it deleted from the docket, so.
There might have been a reason. Let me check.
I know the case was transferred. Was it transferred to Lerner Rent? Did the judge
That's what I'm
issue it?
checking.
Yeah.
Was it?
Is she in custody still? Which jail is she? Okay.
She was at Broward first time.
All right. But she's not on video, though. We can't get her on video.
She's not on video. What I'm asking is.
And
Okay.
she's scheduled Your Honor, she's scheduled to see Judge Lerner Wren tomorrow morning.
Okay. All right. Perfect. All right. Anything else we have? All right. Great. All right. Thank you.